Hello. Yeah. Hello, good afternoon to one and all. Very special good afternoon to Alka Mehta madam. Uh, as we are dealing with these 3 days webinar entitled right uh, yesterday regarding origin. Uh, as I heard yesterday, I was there with ma'am to listen regarding this as it started from 1300 and now we are dealing with the WIPO nowadays. Very important session we dealt with yesterday. We have seen a little, we have seen in detail regarding the history. Now today, the next thing, very important, again will be discussed by Alka Mehta madam. So now I, on behalf of Oriental College of Pharmacy, kindly request Dr. Alka Mehta madam to proceed for the today's session, the second day session. Welcome, madam.
Thank you, Kansar. Yesterday when we began, we just looked at the concept of what is the intellectual property and what is patents per se, and what exactly does patent mean, techno-legal document, and also we saw that what can be patented and what cannot be patented. So today, from there, we will start further, and today's session we will try to see some amount of type of patent applications. How do we file patent application? What is the procedure to file application in India? What is the procedure to file the application at uh, using patent cooperation treaty? So that's using PCT. And plus we'll also see how to broadly what does a patent document consist of, how do we briefly draft the patent, and if time permits we'll enter into the concept of what is the what is called by infringement of patents. So and while we deal with the concepts and the history and how it happened, what are the current procedures, we will keep I will keep updating on everyone on the Indian Patent Act and its provisions, because in 3 days session otherwise it will be difficult for us to actually go through the every section of the act. Nonetheless, the Indian Patent Act is pretty elaborative document, and uh, an interesting one too. So, and incidentally, as we learned from history yesterday, the TRIPS agreement has been TRIPS agreement had given. We saw yesterday that TRIPS agreement had given some standard parameters which are to be used, or which are to be kept in the Patent Act, or by every nation who's member of the TRIPS country, so who's member of the TRIPS agreement. And as per Khan's questions, we also saw that how we saw the entire history, how GATT came. GATT was, as Khan sir asked, GATT was signed in 1947. It came into effect from 1948, and it was ratified in 1948, and it came into effect from July 48. So now let's begin further with the type of patent applications. And like yesterday, I would request Hansa to, if there are any questions, if you wish to interrupt me, you can stop me and interrupt me, or you can post the questions in chat form, and we can handle the questions at the end of the session. Okay, so let's continue where we left off with the types of patent application. So when we say it is ordinary application, usually what happens is when we'll see in a while, we'll see the concept of how we start chemistry development. We all know, being students of pharmacy, that how a chemical entity is searched. So you screen very many drugs, and then of a particular class, or of a particular class, or of particular variation, or of a particular chain, or of particular substitution, and then, like azoles or gliptins or fluozins or etc., 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 for different therapies. When you screen almost thousands of drugs, you come across at least a group of 8-10 drugs, and then you narrow it down to a few groups of compounds, and then finally you would wish to claim, I mean, you study its effect, and you wish to claim those if you find a positive results. So now, while doing all this, this is obviously not 1 year's or 1 month's job. It takes years to develop a chemical entity, and therefore it is usually difficult to have the patent specification or a legal document in one go. So what is and of course, people who have devised patent law, they understand this difficulty for science, and that's the reason they've given a provision to file a provisional application. That means that you file one application with just the scope of your work. You need not file the complete legal document with claims, etc. You can just write the broad scope of the work and file the application, just to retain, obviously, because as we saw yesterday, the patent is always counted, the exclusivity right is always counted from the date of filing. So the first to file is very important. So if like for example, if two people are working on it, the person who files for patent first gets the exclusivity or the monopoly right. So therefore, to capture the priority date, or the first, it's called as priority date too. So the first filing, you file with the provisional application with the scope of your invention, and then further file and complete specification within a year's time from that particular date of filing. In worst situations, you can shift, or you cannot shift that 1 year date. You can extend it for 3 months, but that is the law gives you that provision, but it is your priority shifts. So ideally, we have to believe that, suppose it is today 22nd September 2020, if I file a provisional application, I have to file a complete application on or before 22nd September 2021. So that's a written rule, and that is to be followed. So you can file a provisional application. You can file 3 or 4 provisional as your scope keeps on increasing or keeps on narrowing, whatever you want to. And then in the end, before a year's time, there's a provision that you can combine all the provisional to 3 or 4 or one, whatever, one provisional or two provisionals or 4 provisionals, you can combine and file one utility application or one complete application, provided there is a unity of application, in the sense, for one invention there is one patent. In one patent, you can't have more than one invention. In the sense, if it is claiming a product, you want to claim a product, uh, you can claim its use or its uh, manufacturing process. But if you want to, if there is a novelty in process, if there is a novelty in use, it is advisable that you file those separate applications to maintain the unity per patent of the invention. Okay, so now, having said that, one today, like if we have filed on 22nd September 2020, if we have filed a provisional specification, in a year's time, when I'm ready to file a complete specification in India, I'm talking of India now, what happens if my invention is very good and I want to have the trade? Yesterday we saw that finally we filed patents for trade purposes. So if I want to have the business in more than 3 or 4 countries, but every country, as per trips, they're all trips member countries, so they all will have the same date of filing. So uh, if I file after 22nd September 2021, and once I finish India, and then if I go to file, obviously my own application is going to be a prior art, or if an earlier literature for me, because it will publish earlier. So to avoid that, PCT, you can file a PCT. So that's also called as a convention application. So when you're ready to file complete, we will see in a while how can you utilize PCT once you have to file in more than 5 or 6 countries. So, however, one has to keep in mind that PCT is obviously when you're filing through PCT, we'll see the reasons, but you are going to incur little more amount of expense than filing only in one nation. So PCT is only going to be cost beneficial if we want to file in more than 5 or 6 countries at a time. So you can file in 153 countries, but it should be only justifiable for cost if you want to trade, or if you want to have a business in more than 5 or 6 countries. And then once we'll see the PCT procedure, how the national file application comes. So now once when complete application is filed, it so happens that the obviously the research doesn't stop. So the research goes on. Now you have done some, you took a complete specification for particular formulation, and suddenly you realize that okay, you had added oxidizing agent, or you had added swelling agents or whatever. Suddenly you realize that even using certain excipient, the formulation yields a better dissolution profile or a better bioavailability. So in that sense, or for example, you file for a process and you realize that the by using certain modification, you've reached out a better process. Now what happens is, there is a novelty to these increments, but there is obviously, because you've already disclosed that in first patent, there is no inventive step, or the second step is missing, because it will not come out of obviousness, but it is still a new, because you've done some new modification to it. So there is one, but now when you go for trade, you're going to use this new process or this new formulation. So how do you protect that? Law gives provision for that also. What you can do is once you filed a provisional, obviously till you file complete, you can file n number of provisionals to include the modifications. But even once you file complete, or once you file PCT, or once you enter in national phase, also you can file continuation application, patent of addition. In US, you can also file continuation in part, whereas whatever is the new part, which is extension to the application, can even be valid for 20 years from the date of filing. And so continuations, applications of patent of addition would expire at the same time as that of the original application, but only advantage you get is the modification is also counted now in your. So if you want to market with that new modified process, or modified use, or modified label, whatever you want to say, or modified formulation, that is going to be easier by doing patent of addition or continuation application. So of course we are not going into the intricacies of the law, which gives you that how you have to file the continuation application, but basically this is also a type of the application, so I've mentioned this today here. So now let's move to pharmaceutical patent types. As we all know, uh, there are product patents, process patents, and use patents. So uh, I've written here product patent and composition patent. Nonetheless, patent is also a product patent. But just to say that, I wanted to mention different pharmaceutical compositions. So even if you file ondansetron tablet, or if you file a patent for ondansetron injectable, or if you file ondansetron for um, uh, delayed release or once a day formulation, whatever, you can have different patent for different formulations or different compositions, and that will be treated as a product patent. So obviously these things would be counted as product patent. So that's new chemical entity, NCE. Different polymorphic forms, you see there are different forms, there are different patents, different crystalline forms of a molecule. amorphous or anhydrate form or different hydrated forms of new chemical entity, a gene or a protein or peptide. So all these can be counted as product patents. Process patents are pretty simpler. If if there are different methods like a plus B is also X, or C plus B also leads to X. Now, both of them, they lead to the product X, but the method of manufacturing is completely using different ingredients. X is produced by A plus B in one process, and in second process it is produced by C plus D. So when obviously if both are novel and inventive, you can file a patent for both the processes, even though it leads to a single product. So then there is product by process. So like process, if there is a claim like this, process for making polypeptide by using recombinant DNA technology. So that is what we call product by process patent. So only patent owner is used to use or commercialize a product patent. uh, of course, there are challenges to this, but let's not go into the intricacies for time being. Method of use patent is different uses. So as we saw, I mean, yesterday, as I was telling you, aspirin or Viagra or sildenafil citrate or metformin, or there are any very many other drugs which for their example, the COVID-19 molecule remdesivir. Initially, it was the and what you say, the discovery was being done on uh, it as an anti-HIV, but now the it is also being found as useful for severe conditions in COVID-19. So that's a very useful drug that we have received as a next use patent. So here is the patent filing procedure in India. More or less the similar procedure you would see in every other country. Nonetheless, some minor modification or minor rules are there. So let's understand the patent grant procedure. Um, First, either it is a provisional application or a complete application by any patent office. You will file on, suppose you're filing today. As I told you, within 20 months, you need to file um, application for, if it is a provisional one, within 12 months you have to file a complete application, which is with a complete application with claims, drawings, all the forms of declaration for inventor, or whatever your address proofs, etc. Whatever are the forms that are required to file the patent application. So those you have to file. Usually, once you file a complete application, within 1 month, you're supposed to file the rest of the forms and the documents, including the specific fees. Now, Indian government or Indian Patent Act gives you a provision of an individual as a applicant, or a corporate as a patent applicant. There are separate fee sets for individual as well as corporate. So, because obviously, patent office understands, or the government of India understands, that if you are an entrepreneur, or if you are a scientist, and if you are an individual not associated with any corporate, obviously you want to encourage invention filing. You're going to file, but only if it is not costly you will file it. Otherwise people would not be attracted, even though there is a lucrative business opportunity of having monopoly rights. Obviously the cost is a factor that every Indian rather is sees first. So corporate prices are different, and Indian is different, and there's a separate table for it. So you file application including the claims, and then once that is filed, all the forms are filed. In every sense, the filing is complete. Now, post this complete filing, you have to file the request for examination. So this is a time period that Indian Patent Act gives you is 48 months. So once you file, then you have 48 months to file the uh, request for examination. And meanwhile, once 18 months are over, your application gets published in the patent journal. So which is anyone can see it. And once the patent application is published, the abstract or whatever is published, and people come to know, what is the invention, and regularly this publication happens. Now for some reason, if you are working on a secret invention, there is a provision that you can fill the form, that if it's a uh, you know um, weapon invention, or if it is something which is useful, or which has to do with secrecy of the India, obviously you can request and stop the publication of such things. If you want the patent to be granted within a year, you can expedite every process, and so within 6 months a patent, instead of 18 months, you can get it published within first 6 months. So like, these are the shortcuts that you want to use it for trade if you want to still have a patent uh, within certain stipulated time period. So once it is published, then anyone who's interested can file the pre-grant opposition. So if they don't agree, they don't think that this is they think this is obvious or this is not inventive, obviously then you can have they can file pre-grant opposition, and patent office would hear the pre-grant opposition, and they will decide whether to continue the patent examination or no, or to abandon the patent, or to ask the patentee to abandon the patent, um, or ask him to the applicant to amend the patent, whatever it is. So rest there are very many countries who has pre-grant provision now. uh, but pre-grant is, you can, after publication anytime till grant, you can file a pre-grant opposition. But sometimes it is seen this as people use this as a delaying tactics, in the sense, if you challenge someone's patent, the patent office will have to first decide on pre-grant before they actually give uh, the grant of actually go ahead to give the grant of the patent. So this actually delays the process. And if a person has what happens is, thanks to the bureaucracy, that is also seen that sometimes the examiner of India, they wait till they get, if the person is filed through PCT, or if into any other country like Europe or Australia or US or New Zealand, they just wait for those reports, and then based on those examination report, they decide. So uh, this is also seen as a delaying tactics. But nonetheless, pre-grant opposition is there in some countries, but in other countries like Europe, there is nothing which is called as pre-grant. But in European countries, what happens is, they have a provision of filing observations. So you can file observations to patent office if you feel that there is a inventive step which is challengeable, or which is not which is obvious. You can always file a challenge or the observations. There are certain rules to file the observation, but by and large, you can file the observation to the patent office. And like India pre-grant opposition, you have the provision of hearing the pre-grant opposition. There it is not mandatory. It depends in the discretion of the examiner whether you need to take into account the observations filed or no. So the next step is, once if they file pre-grant and examiner goes ahead that okay, or rather the patentee wins pre-grant opposition, the patent examiner goes ahead and grants the patent. So now once a patent is granted, you still have 1 year's time to file a post-grant opposition. Now the 1 year time is in India. In Europe also you can file post-grant opposition. Now as per the new Patent Act, in US also you can file uh, post-grant opposition. It is called PGR in US. So both this thing in you, but Europe you have 9 months period to file post-grant opposition. So invention is post once the post-grant opposition is filed, you're supposed to both the parties are supposed to file their uh, whatever their grounds are. The grounds are heard by the opposition board, and then the board decides whether the invention is granted or is rejected. So you can also appeal the decision for uh, pre-grant or post-grant with the IPAB, Intellectual Property Appellate Board of India, or even at the High Court level. Okay, so this is in short the patent filing and grant procedures. So now let's come to application procedure to file a PCT application. So people also call it as international patent application. However, let's understand one thing here, that it is just a filing access to us. It is the moment I file international patent, it does not mean that I've got a patent granted in 153 countries or internationally. I still have to go through the national process for in every country for patent grant, as per whatever that those countries rules are. So but it's only PCT enables me to file at a time, or it simplifies my process of filing the application. Let's see how. So we saw yesterday that there are 153 contracting states to PCT. So as you can see here, there is a zero or a priority date, and from 1 year. So once you file a provisional, you can have a PCT filing date in first 12 months, and then once you file that PCT, you are going to indicate that you're filing PCT, and there are assignment forms, or there are particular forms, etc. So within 1 month time, you're going to again, finish out the formalities with the base formalities. So once that is done, within 2 months, you get when you file PCT, you are going to choose what is the international search authority. So now there are 5 or 6 countries which are designated as international search authority. So US and Europe are the leading search authorities, and they, because they have advanced patent search system, or they people usually prefer, but there are some other search authorities which are cheaper and yet good, like Austria, or India also is getting ready for international search authority. So and then they issue a written opinion, so within 16 months, and by the time your application gets published again in 18 months, you may have your ISR reports, and then you can file for uh, uh, file a demand for whatever international preliminary examination, or in any further supplementary search, or you file the demand, or you file the amendment, file for based on the report. You can file for amendments, or you can argue with the examiner if at all there are comments on novelty and inventive step. So now, based on that, international preliminary examination report, it used to be called as earlier. Now it is called supplementary international search report. So SISR. So that once you get it within 28 months, so you can now decide. So now we are at 0 to 28 months. So now once based on SISR, you decide that, okay, this shows that my invention is good, or it has novelty and inventive step in uh, with respect to XYZ claims. So now I'm going to choose it, that which countries I want to commercialize my invention, and accordingly to whatever 6, 7, 10, 12, 30, 40, 50, 90, whatever country I choose, I'm going to file my patent application. Now be aware that in those countries, you have to have, in these 30 months time, the PCT gives you time to go through the searches, go through the actual amend your claims, go through, find out an attorney there. If there are any translations required, you have to, because certain countries in Europe or certain parts of South Africa, or you have to file the translations too in their origin, in their language, where patent office can examine. So all such things you cannot do on, as a one person. So you will definitely require that particular country's attorney. So these 30 months time is given for that. If you choose 10 countries or 12 countries, obviously you're going to get the time to hire an attorney, do the search, find out how you're going to file, what is the procedure, etc. in those countries. And in some countries you can enter in national phase at 30 months. Some countries of 153 they allow you to enter in 31st month. So as the requirement, or either in 30th month or 31st month, you will enter into the national phase. And that means that once you enter through national phase in that particular country, say for example you filed a provisional in India, you filed a PCT you filed through PCT, but you filed from India, you have entered through PCT now in US, and now so in whatever 30th month. So once you enter in US, the application will proceed as per US country law. So the novelty, inventive step, or commercialization definition would now, your patent would be assessed based on the laws which are existing in United States at that time. Okay, so this is true with all the countries' applications where you file, and that is why we see that now all these, like suppose after going through rigorous examination, and your patent is granted in Europe, in Australia, in New Zealand, in South Africa, in India, and in US. So. And in Japan. So now you've got this your patent granted in these many countries, and now all these patents are called as family patents. In the sense, they belong to one priority date, and they belong to the same, because they belong to one priority date. They're called as one family. So remember, if you have one. It is just like a family when you have only one head of the family, and then rest of it are son, daughter, daughter-in-law, son-in-law, nephew, niece, etc. So nephew, niece are continuations in part here. So all that is one family for so now see, one invention you've got into so many countries with so many family patents for the same invention, which you want to, now it is ready to market in all the countries. And depends on the time that each country has taken. Few countries, they even compensate you for the time. They will give you extra patent time or extra monopoly right, which is extended, which is also called as patent term extensions. So term extensions exist in all the developed countries, so like Australia, Europe, US. So if time permit, I will show you either today or tomorrow. I will show you some of the patent exclusivities or patent term extensions. Those are available. Those that are available for those countries. So that you get at least maximum 14 to 15 years of patent trade life. So not the patent life, patent trade life. So now, so that's about PCT application. I hope it was clear and interesting. Nonetheless, once the patent is granted, you need to validate or pay fees according to, as the patent was examined as per those countries. You also have to pay the fees for those countries. So now let's see. So as we saw, there are a lot of activities involved, or filing is a lot of. It's a very complex this thing. So let's see what all activities are involved in filing. It's a huge exercise that we realized just now. Of course, as I told you, the cost is associated with prior art search, official filing fees, uh, agent fees, attorney fees, maintenance fees, etc., etc., etc. So once you file, you have to even if it is foreign filing, you have to also count on translation cost or local agent or attorney fees. And once the patent is granted, you have to keep on paying a patent. Once the patent is granted, you also have to pay patent validation fee. So that is the initial fees at the time of grant of the patent, and in some countries, and also you have to file for maintenance till if you why maintenance is required. If you don't file maintenance, if you stop filing the maintenance fees, say after 5 years or 6 years of patent. So once a patent is granted, uh, you've already started manufacturing, and your manufacturer is your product is already traded in that country. It is almost now 13 years have passed your post your filing, and you have already started trading. uh, why do you think if you think अरे बहुत cost हो गया, so now why I do why do I need to keep paying? And I stop one fine day I stop paying maintenance. What happens is, that means my protection or my monopoly right is lost. So the moment I stop paying maintenance, the patent office is not bound to keep my patent invention or my monopoly right in record. So the reason the result is my rights are gone. So anyone can copy my invention before 20 years. If they see that I have not paid my maintenance fee, that means I am not interested in keeping my invention or my monopoly right alive. So it is interpreted in that way. So sometimes accidentally you have forgotten to file the maintenance fee. You can revive. You can file an application. The law gives you provision that you can revive, but law cannot do anything if there is a period which is lapsed in. And that period, if someone comes in starts marketing or manufacturing, unfortunately law cannot help, because during that particular period, be it 6 months, 8 months, 2 months, that you forgot to file the maintenance fee, your patent was not your rights were not valid. So because your patent was not maintained, uh, of course once the rights are revived, for the from when the rights are revived, you can claim the monopoly right again, but during the period that is lost, you will lose the battle. And this is particularly everyone has to remember, specifically with respect to device or design patents. This is pretty important because we come on with modifications, so it is important that person keeps a track of what is the last modification, whatever is the last modification that still remains patented while the when you are commercializing the product. That's pretty essential from a pharmaceutical design or device point of view. Okay, so uh, I did tell you when to file a patent. It's always first to file in every country. Whomsoever is first to file. In US, up until 2012, there was a provision to grant a patent to first to invent. In the sense, if person A has invented, and person A and B, both of them were working, and A started earlier to B, so that means A is first to invent. But A had because A took little longer time in um, finalizing the formulation or finalizing the process. In between, B filed the uh, uh, B took a chance, and B could crack the commercialized formulation E first, so B could file the patent earlier to A. In that case, United States used to investigate. There was a procedure to investigate, and they used to give the patent to first to invent, but that was only up to the new America Invent Act, that is AIA, came. So as per AIA, which came from September 2012, now even the new AIA, uh, it is first to file would get the patent, and even the new AIA only has opposition procedures. Earlier, there was only patent re-examination or re-examination that was available in US. So how long does it take to obtain a patent? So we just took that it's a huge exercise. So you have to file many forms. So as you saw, the procedure is also a bit tedious. So obviously the patent office also takes time. They have to do a patent search, etc. So the usual time is it varies from patent office to patent office, but the usual time or a average time is seen as 2 to 3 years for a patent to be granted. Of course, as I told you, you can get the patent granted even in within 1 year, but uh, if you want to file under expedition. And it is 20 years, the protection is 20 years from the date of filing, and I told you we'll see in a while what are the term extensions and it is available to which countries. So here are a list of activities which are there, like patent search and analysis. So before filing a patent, obviously, how do I know that my invention is novel and non-obvious? So for that, I have to get the novelty search. I have to get the freedom to operate search. So if I want to market that invention, whether are there any other countries who are marketing similar invention, or they are there any similar patents or etc., or patents which relate to similar drugs or different similar kind of formulations, etc. So am I free to operate in that country? So I have to do, if that is also called FTO search. You have to do FTO or state of the art search. State of the art is whatever is the whatever information which is published till date of the till date with respect to the inventions is called a state of the art. Then you have infringement search. So if whether somebody is copying your invention, so there are different kind of searches that you do. uh, then prepare for draft particular patent, in the sense you have to draft every part of the patent. We'll come to we'll just see in a while what are the different parts and how there is a specific pattern, how would we draft those patents. Then uh, prosecute, in the sense once you submit the patent, you file for examination, the examiner is going to perform his own search, and once he comes up with his doubts, you will answer the question to the questions of examiner. If examiner get some different prior art and he asks you to justify your invention in the light of those prior art, you will again submit your response to you'll study that, or you'll search again, you'll prepare a response and submit it to the examiner. Or you can also submit few experiments or the results of few experiments as per whatever the requirement from the examiner. Give that or submit the response to examiner, the examiner. Or you can then have one more dialogue, or like this is goes to and fro till the examiner is convinced that your invention is novel and inventive, and he grants you a patent. So that is called prosecution of patent. Then once it is granted, you need to file, maintain. And as I told you, if you have one application, or filed in say 50 countries or for 60 countries, then you need to maintain the patent in all 50 or 60 countries. So that means you need to docket those family patents. You need to keep on, if every country definitely would have some or the other difference in the claim. So you have to remember those claims when you're marketing in that country. So of course you need to do patent proofing or correction in this document as per the country requirements. Then you need to maintain the dialogue with examiner in every country. So that's the prosecution or file histories of the patent. Then you need to file the final patent once it is granted, or you need to file the translations of the patent. Or for if you have filed for one particular patent, if you filed say first in 50 countries, then you did some modification to the formulation, you filed a continuation application, or continuation also you filed in 50 countries. So that means likewise, if there are if you're working in R&D, and if you're working on 4 or 5 or such products, just imagine that you need to do now a patent portfolio management, in the sense for one invention you have X number of patents. For second invention, you have Y number of patents, and every single time one or the other patent, you have to check for maintenance, you have to file, you have to answer to the examiner's response, and likewise the work increasing. So there is a specific staff or software is required for patent portfolio management. Now, once you have a group of patent that is granted for one particular product, so like say for example, for one particular product, you may have filed for its formulation, its use, its if it's a combination products, its combination, its dose. So likewise, there are different types of patents for one particular product when before you're marketing. So, and if you want to buy certain product from someone, see like yesterday I was talking of when we talk of Pliva sold their invention to Pfizer on azithromycin. So obviously, whenever whatever Pliva had filed earlier about the azithromycin entity itself, or the azithromycin use or azithromycin formulation, they've licensed in the entire patent portfolio to Pfizer, and then Pfizer did extend the patent portfolio. So that's the patent licensing and commercialization work. So I'm just trying to show you the kind of work which is part of routine intellectual property management department of any company does. So be it a pharma company or be it a non-pharma company, this is kind of I'm giving you the glimpse of the work that every intellectual property department works on. Okay, so then you also need to suppose, say for example, I'm not deliberately not taking a pharma example. Say for example, you have um, Surf Excel Matic and Ariel Matic soaps. So more or less, you can see both are based on nanotechnology, and you have both the products. Now some of the newer patents or newer in Ariel Matic has revised its formulation, and Surf Excel Matic people comes to know that they've added something which was looking at Surf Excel Matic. So now they want to file a suit. So what they will do it is they will take those group of patent which is published for Ariel Matic. They will compare the claims, and they'll prepare those charts. So that's they'll do claim charting and then compare each claim, and then think about the challenge. So all that work is also done. Even if you want to buy a license on some technology, you do claim charting. Of course, then when you assert someone your right, or when you're defending your rights, you need to hire attorneys, and the entire litigation battle goes, which itself is a very big one in it on its own. Let's not go and delve into the assertion, otherwise it requires almost another group of lectures for us. So these are the different stages in patent life. A patent document sees pre-preparation. So that is, you draft, do a novelty and inventiveness search and draft an invention. Then prepare an application, be it single national application or a PCT application. Then fill the forms, then do the filing, then do PCT filing. Then you have the office actions, that is examiner raises questions, and then you file the responses. And you're supposed to also file, if suppose your application is under examination for in US as well as in India, uh, to both the countries, you need to file whatever are the to an Indian authority or Indian examiner. You need to file what happens to your US family patent, and in vice versa. So in US, you have to file what happens to your Indian or Australian patent application with the same family. So that is called the disclosure requirement, that you have to in invention disclosure requirement, that you have to file with every country patent examination with respect to all the family patents. And then once the patent is granted, you have to maintain the management and do the corrections of the patent claims, and also manage the portfolio of the patents. So by and large, this covers things on patent preparation, filing, and prosecution. So I hope this was clear. Of course, if there are any question, you are definitely welcome to ask. I'm just trying to take a broad outline introduction of filing and prosecution. So, in a nutshell, what we're trying to see is to obtain a strong patent. What do I understand of a strong patent? So, once a patent is strong, that means I can attract investment, I can license out, and most this thing, if I don't want to do it, I can protect my business advantage, and I can, and at the end, I can reduce competition. So, the biggest example of such this thing is. Today, you see in India, Merck's Januvia tablets or Janumet or Januvia, that is sitagliptin, is the strongest. So, sitagliptin patent was granted way back in in the beginning of this 20th century, and you see that in 2004, 3 or 4, and you can see that the patent expires after 21. So there are some one group of patent expires in 21. There is a phosphate patent, then it expires in 22. Then there is a hydrogen phosphate and its use which expires in 24. Then there is one patent which expires in 26. So they have a lasting protection till 26, and all these patent or patent groups are considered as strong patents. Specifically, the first patent, which is the chemical entity which claims a sitagliptin monohydrate, that particular patent is pretty strong. There were, in different countries, people tried challenging the patent in US or in India. They were not successful. So such a patent is termed as a considerably strong patent. The second example that I remember offhand is Raltegravir. So again, that is Merck. That's an anti-HIV product. Again, the patent is so strong that Merck themselves have given license to the patent. So likewise, even Merck for sitagliptin has given license to Sun Pharma to distribute as a sole distributor of the product in India. But nonetheless, people they tried challenging those patents, but they were unsuccessful. So till date, Januvia and Janumet are costly for than the normal price of the tablet. So, though Januvia and Janumet are available in India at a lesser price as compared to the other developed countries, but nonetheless, still for diabetes patient, the average price is pretty high. So that means, and plus, there's no competition for almost 13 to 14 years. So if you have a strong patent, you can have that. So it's important that when you are so now what precautions would you take when you are quickly we'll see what precautions we need to take when we draft the patent. But let's first understand what is the scope of our patent invention, or the scope of our invention, or what is the breadth of our invention. In the senses, if I explain you in very simple term is I want to buy um, I want to buy a house. So what will I see is, of course, spare me. I'm not going to talk about Mumbai buying a flat. Let's say that in Lonavala you're looking for a house. So what will you look is when you go to buy a property in Lonavala or in Khopoli or wherever, a second house, what you try to see is that whether it is situated, A is in good locality, it is accessible. Then 3 is it has all the basic amenities, its construction is strong. Then there is in future, if you want to expand, whether there is provision to take FSI on top, or you can expand it or make a garden outside. So that means basically you can increase, or you can expand on the on your land rights. So similarly, we're talking of property, intellectual property patent. So the same thing would apply here. when you're looking at a patent scope or an invention scope, I would say, what we would try to see then. So now correlate it with property. The moment I said, you look at good locality, or you look at accessibility, you're going to look at the current therapy and the use of that particular product or formulation or your invention. How can you use that invention? So obviously you're looking for excess, good locality and good excesses, because you're going to stay in house. So if you're going to, similarly, if you're going to use your patent for 20 years commercialization, you need to see that how persistent or how strong is your invention or its base, so that it runs for 20 years. And there is, don't we shouldn't be spending or investing in so much that within 2 years something new comes up and this gets this just goes off, or the technology gets wiped off. No. So you need to analyze from that angle. So accessibility, good locality is done. Now you see that it has a basic structure. So basic strong construction and basic amenities. Now this relates to how well you define your scope of the patent. So that means how well you define your invention, how well you describe. Are you describing the best mode? Are you describing the way you have manufactured the invention? That means your patent specification or document is strongly constructed here also, including claims, obviously, because claim is the only legal part of your patent specs. So including that. And then now let's come to whether you can expand that in future, to you can have a grill which is reaching 10 meters or 20 meters or 15 meters outside, or you can have a garden in another 25 or 50 meter, or you can build a terrace on the top of your house. So these are like expansion, this thing. So likewise, now look at the expansions to your patent application. So within 5-6 years there will be a technology advance. So whether using these ingredients would work for 20 years, or you should also include this, which will which is still in the scope of the application, but it will cover you for 20 years. So that is what extensions or expansions are possible within the scope of your invention. So you need to think of a present and a future document, which is one now. So therefore, what amendments or continuations, or at least which is not ready with you now, whatever is ready with you. So this is, you don't have money, so you don't want to do a terrace now. So what you would do is okay, you will mention that it can also have, house can also have terrace. So likewise in the patent, you mention about the scope of or that particular thing which you think you can expand, and file a continuation application once you are ready with the experiments in effect. So then you can have 3, 4, 5 continuations applications. So that's the way your expansion plan is. So this is what you need to think when you are writing your base document. So that means it is pretty important that we understand the invention and its conversion to future product. So the moment I see the empty house built in, I should know while entering this room, okay, this room is there's a this room faces east, so this is very good for, say for example, I'm no vastu specialist, but this room, say for example, it faces east, so you will have a temple here. Oh, this room faces west, so let's have kitchen here. Oh, so that way, that way now you will understand your invention with respect to commercialization. So how does it relates to business? Or what is the invention date? When can you commercialize it? When have you filed it? When can you commercialize it? So that will show you whether there is a need to file any extensions to the patent, right? So whether you need to apply for any continuations or extensions of your marketing rights. So who all are in the area? So obviously when PNG is filing something, they have to look into Hindustan Lever or Patanjali in their mind, or how will they compete with respect to that particular product. And uh, and of course, how if it is a new product, what is their market reach, or what is the manufacturing, whether you would require different kind of equipments, or whether you would require different kind of storers, you need different packing, etc., etc., etc. So you need to understand the competition. So now, with having that understanding broadly, let's look at the parts of the pattern. So these are the basic parts of the pattern. So I've just shown you the basic title. So title is one. These are the pattern parts which you can see on screen. Title, technical field. There's a spell error here. It is FIELD. Technical field, background and description, problem solution, object of invention, statement, detailed description of invention and detailed description of drawings, then examples, claims, any extra drawings. So this is how actually you see it. Now let's quickly understand what of them, and then I will show you one particular pattern just to understand how the patent is written. I'm sure you would have seen a lot of patents. So this is title is something which in short describes your what your patent is about. So it should not be too long, and it should not be too short. If sometimes people search through inventions by using title or technical field, so it's important there you mention something which describes peculiarity of your invention in title, if it is possible. uh, mm, then technical field is what is the preamble, like what is it invention relates to. It's a nanotechnology formulation, or it's a formulation of raltegravir, or it's crystalline forms of raviprazole. So exact likewise, you can describe that's a technical field is what is the patent about. Then in background and description of the art is something, this is most important part. Here is, here you are going to describe what is the background. So what is the background technology, what is the prior art, or what is the literature search that you have done about your just before having that surprising effect in as your invention. So suppose it's a process patent, so what all were processes were available, what was the yield that was available with was that process, with which kind of, whether those processes were commercialized, whether there was an impurity which was coming out of that process, whether the process was very time consuming or very done on high temperature, etc. So what was the background, and from the background what was the problem that was there in the prior art, why did you choose to work in that area. So what is the surprising solutions that you've got. Suddenly you were working uh, one invention or one process was at very high working at very high temperature. Suddenly you realize that by addition of one catalyst, the uh, uh, not only the temperature reduces, but also you can, I mean, with that addition of that catalyst, you can perform the reaction at room temperature, but at the same time it also gives you significant rise in your yield of the final product. So that means this is definitely this is something an invention. So there was a problem in the prior art, that it was a, what do you say, low solubility product or the reaction which was carried out at a high temperature, and it was difficult at a long reaction, and now you have reduced it to a shorter this thing at a room temperature, and with obviously almost significant increase in the yield of the product. So that's a surprising solution that you have got to the problem of the prior art. Then what is the object of your invention? Obviously to find out a process for so and so. So here you are going to write all the possible elements as your object of the invention. So whatever whether it was you were developing a process, so whether the object was to have the better yield, or have better uh, workability at a room temperature, or easy step of reaction, or reducing the time of reaction, whatever. So those were the objects of your invention. Statement is something which is demarking or marking your uh, actual claim or actual fence of your invention. So what is, like, statement is something which I can compare it with a fence of my house. So okay, this is like my house is 10 acres, and plus you have 100 yard of garden space. So it is this 10 plus 01, so that's the fence of my house. So that's that way you are going to determine the statement is your what you say, independent or your claim of the invention. Then detailed description, as I told you, your present and future elements you are going to include in that to structure your specification well. Then you will write the whatever examples, actual examples, the process of manufacture, the experiments that you have done, the efficacy experiments that you have done, and some of the drawings that graphs or something, or bioavailability, etc. And 150 words or whatever, the abstract of invention. And last but not the least is the most important part of the patent, that's the specification of the patent. Sorry, that's the claim of the patent. It is also called as, so far without claims, whatever part of the patent is technical part. Claim is the only legal part of the document. So that is why patent is known as techno legal document. Techno is specs, legal is claims. Let's see one patent here. I'll show you one patent here. Document. One sec.
Completed the session, madam.
Hello?
Done?
Yeah, done. Can you see the screen?
Okay.
Hello? Is the screen visible, Khan sir?
Yeah, it is visible. We can see you.
Okay. So this is a, US patent. As you can see, there is a date of patent which is written. The date of patent is the day patent is granted, and the file date is mentioned separately here on the left column. And you can also see the examiner has cited other publication is the prior art that is cited by the examiner. This is the abstract. Just see, it is 150 words. So, and it also mentions on the first page, this is also known as bibliography of the patent. That is the first page of the patent. It has title also, the name of the inventors, and whether it is assigned to, this patent is assigned to CSIR. So this is CSIR. And as you go along, now the patent specification starts. So this is patent specification. When you saw, this is technical field that we saw right now, background and prior art of the invention, then the object of the invention, then you have the summary, so there all the elements are written. Then there is detailed description of the invention on how it is performed. uh, then here you can see that example, formulation is made, so formulation along with the percentage is given. So the examples are given, there are some 5-6 examples given. And apart from that, then later you see there is a table of efficacy test that is done. So the testing was done on whatever animals or humans, that is given here. And once everything is over, the claim part starts with this sentence, which is very important: we claim. We claim or I claim is a must, because that's the demarcation of specs and the claims, the legal part. This is the first claim, or then these are the 8 are the claims. So this is a simple patent application. So now, since we are here on patent claims or on the patent, I want to try to show you. I'm just zooming this document so that you can see first claim. Normally, when you see the claim, as you can see, this claim is divided into 3 parts. If I say that the first part is a herbal anti-allergy formulation. The moment I say it is a herbal anti-allergy formulation, that strikes me that this is an invention about a herbal anti-allergy formulation. So that is something which describes the uh, patent specification is about. What is the patent specification is about? So this particular first part is known as, this is known as the first part of the claim. That is also called as preamble, because it is describing the prior art, because the herbal formulations were known. Then the next part is comprising. So this is like what is the herbal formulation of this invention is. So before the invention starts, the connector is used, which is called as comprising here. So the second part is that connector. So comprising, consisting, including, whatever you want to say. So that is connector. That's the second part. The third part is the actual invention or the body of the claim. It is also called as, or elements of the claim. So that's the actual or most important part of the claim is a mixture or a juice or extract of A, B, C, D, and E, comprising one or more of pharmaceutical additives. So that means this is the first claim, which mentions the preamble, a connector, and a body of the claim. So these three parts. And when you, the moment you say, preamble, connector, and body, the body in the first part of the claim, or in the first claim, would mention the all the elements of the invention. So that means the moment I say all the elements, means without any of these elements, the invention is not an invention. So if I miss Tiniospora cardifolia, or if I miss Albizia lebec, this is not the invention that is described in this patent. So all the essential elements are mentioned in this claim. This is also considered as first claim, or is the independent claim. So the moment I say independent claim, that means there are going to be dependent claims also. So now, if you notice, the last part of the claim ends with the balance comprising one or more pharmaceutically acceptable additives. So your first claim, you don't want to make it too long. Remember one thing, there is no full stop in entire three parts connecting. So the moment you put a full stop, your claim ends there. So please don't do that mistake in writing or drafting a claim. It, even if this is one part claim, sometimes what happens is you can also have a long claim for to describe a device. So those can be two-part claims also. Now how that would be written is comprising or characterized by, then there will be another connector that will be used. So comprising or characterized by A, B, C, D, E, whereby or wherein. Now whereby or wherein is a second connector. Whereby or wherein, the first part does so and so, characterized by so and so. So that means does so and so, characterized by so and so, becomes the, so after wherein whatever part comes is the second part of the claim. So you can have one part claim and you can have two part claim. You can have independent claim, you can have dependent claim. So sorry. So now we were on the what are dependent claims. So now you had more pharmaceutically acceptable additives. Now you for a good inventor, you need to define what are the additives, or you need to define what are the other characteristics which are also important in making this or preparing this invention. So say if we go to this second claim, herbal formulation as claimed in claim 1, wherein, so now this wherein is a connector that's used. The formulation is syrup or suspension. So in the first claim, it was broad enough. It just says anti-allergy formulation. So it can be syrup, suspension, cream, capsule, whatever. But second part says that it is a syrup or suspension. So now you are defining or narrowing your invention to suspension or syrup. So that's a dependent claim, which is dependent on the first formulation. The next essential feature is that if it is a formulation or a suspension, it has some viscosity or specific gravity. Then it has some refractive index if you want to claim it. So then these are preferred features or optional features. So you will have in the first claim, remember, you will have essential features followed by preferred features followed by optional features. So please and in between you can have more than one independent claim also. But see that For a good application, you should have fewer independent claims. And we'll come to know when we do infringement tomorrow, we'll come to know why we should have fewer independent claims. But for now, at least try and remember that you have essential features of the invention. You have preferred features of the invention. What are preferred features is that you would like to have furniture in the house. So that is what is furniture is your specific gravity, your viscosity, your taste masking agents. These are all your furniture of the house. So that is your preferred features. What are the optional features is you add sorry, I said taste mark. I mean, you add coloring agent, you add flavoring agent, so or you add some viscosity enhancer or stability enhancer. So those are features. Those can also be added. So those are without which your invention or your marketed product is not going to have material effect. So those are the optional features. So preferred and optional. So you can claim both, but do remember one thing is if you have if you are describing something, you need to see that that is claim, because your remember the specification is only your technical part, your legal part is only claim. So that means trespassing is on your property is going to be checked only with respect to your fence. So your fence should be stronger, right? If you don't have those wiring fence, a thief can come very easily. So an infringer is just thief. So if you don't have proper protection legally, so if you don't claim every feature that you've incorporated in your specification, you are exposing your patent to challenge. And even if you don't describe the best method to manufacture the invention, again, you are describing a challenge. So keep this in mind. So now let's go back to the description of the claims that we just saw. So I'll go back to presentation. Okay, so we are back to presentation. So this is what we just spoke about, disclosure. There should be a balance, obviously. The basic requirement I've already explained you. So provisional, we saw the advantages of it. But one should always remember that provisional is something like you have the ticket for the journey, but complete specification is a reserved ticket for the journey, and provisional is the unreserved ticket for the journey. So always remember this difference. So this is what we were just trying to understand. We need to understand the invention. We need to understand what is the prior art and what is the difference between prior art and the invention, and what can be the competition tomorrow. So accordingly, we need to draft the claims and specification. Too much of to and fro with the examiner would delay the grant, and therefore we need to check to have the strong explanations or a strong pattern, so that would limit the question answers from the examiner. So claims are drafted in a number of paragraphs, so that we just saw. The first part or the main claim is the broadest. So we are going from broadest to narrowest, covering both. Function of the claim is they define the exact boundaries of your invention. The primary object of the claim is to limit and not extend the monopoly of the claims. What is not claimed is disclaimed. So somebody, if you've described but not claimed, someone can use that information and manufacture the product. So then tomorrow you cannot assert if you have not claimed that part. So you have to remember to claim every essential, preferred and optional feature which is described. Add as a claim to the specification. Claim is the only operative part, and it makes the distinct boundary and territory for the patentee. So it is also called as meets and bounds of the patent. So here for you, I have given you an example of a process. Suppose, for example, it's a process for, say, unlocking the door. So it has 3 steps. What will you do is remove the keychain with one or more keys from the pocket. That's first step. Then select the proper key to unlock the door upon a color coded system. So you would have a yellow colored key, or a key with holes, or key which is bended, or key with a number. So that's step B. And then rotate the key in the lock, so that is unlocking the door. That is step C. So if you want to describe the process, it is A plus B plus C. So no single step is claimed, but it's a process claim as a whole. So when you're looking at from infringement point of view, it is a process as a whole is seen. But nonetheless, you need to check on every element. So we'll come to it when we actually do the infringement. So we just saw this, that a claim has a preamble, transition, and one or more elements or body of the claim. So which defines the parts, ingredients, steps, use, etc. The body of the claim covers machine process, phrases, ingredients, etc. So which I just told you, meaning of those elements, different ways on describing the technology, the desired result, or both. Independent and dependent claims. We just saw the first claim is considered as independent, or the main claim of the invention. An easy way to differentiate is dependent claim specifically refers to the earlier claim. So the moment you see as per claim 1, or the claim as per claim 1, so that means it is dependent claim, or the claim as per claim so and so, so that means it's a dependent claim. You can also have a dependent claim which is dependent on more than one claim, so that is known as multiple dependent claims. And a independent claim may depend on independent claim or any other dependent claim. So that is independent and dependent claims. We just saw the functional language. The patentees include additional functional language, that is whereby or wherein, and these are typically found at the end of the claim or group of elements, and this is known as the functional connector also, because this usually describes what follows whereby or wherein is the function of the elements. So that is the functional language which serves to limit the scope of the claims. The European Patent Convention, EPC, I've also given you the link here, that gives you in different articles on what the claim drafting, how the claim drafting should be. And this is very nicely and very clearly given, as you can see. Article 84 mentions that the claim should, define the matter completely. It should be clear and concise. It should support, so whatever you claim should always be described in the specification. You can't claim something which you have not described. So there should always be a correlation. And what do you mean by clear and concise? So that also Article 84 further states that it in now Europe sees the invention as problem and solution. So they look at the closest prior art and vis-a-vis what is your surprising element with respect to the last or the closest prior art. So what was that problem in the prior art, and what is the surprising solution you have come across? So that is the problem solution approach, and that is what is European Patent Office sees. So claims must indicate all the essential features. There are no relative terms mentioned in the claim, like they've given examples of these relative terms like thin, wide, strong, etc. And they've encouraged you to use the terms about but not approximate, because approximate again leads to ambiguity. When you say about 5 up to 10%, so that means about gives you a particular range of so it is when you say about this to that, means it is statistically significance is allowed plus minus, so that is plus minus 5%. terms like particularly or preferably, you should use it very critically. In the sense, these terms should be very, very limited for use, and have no limiting effect. So that means ideally they're not encouraging you to use particularly or preferably in the claims. Then claims have to be supported by the description as a third part. That means the scope of the claim should not be broader than, which is, inside you have written it's an allergy formulation. Inside you have described, not describe allergy formulation, and outside you are writing it is an anti-allergy formulation. So that is not done. So whatever is not written inside, you can't claim those. And you should be allowed to cover all obvious modification. In the sense, if you have claimed citrate buffer, you are allowed to cover phosphate buffer also in the claim. So the moment we say water soluble agents like HPMC, MC, CMC, all obvious modifications of HPMC, if you've described in your specification, you are allowed to cover in your claims. So this is very clearly given. EPC, they also give few examples on how will you claim certain things. So like a product for a specific purpose, or product suitable for a specific purpose. This is the language that you would use for uh, claiming a use. Or process claim should be uh, a process process for melting a compound. So they've actually given you the examples on how the claim should be drafted. So let's see some few more examples what EPC has given. These are few examples actually given in articles of EPC, which guides us how to draft a product patent claims. Say for example, the fact that is known to you is the compound is novel. That means, say for example, nitisinone is the new compound, and therefore any use of nitisinone is obviously novel because the chemical entity is new. The inventor has also found that nitisinone is also known for uh, its anti-cholesterol effect, say for example, for treatment of eye. So how will you claim it? So see, they've given the possible claims that you can have it. You can, because it's a new chemical entity, you can claim compound nitisinone, or nitisinone characterized by whatever. You can give X-ray diffractions, or compositions containing compounds. So if there is a tablet containing, or tablet comprising, or tablet here it is written containing, but when you actually draft in claims, it will be consisting essentially of, consisting or comprising. So composition comprising or composition consisting compound nitisinone, or compound nitisinone, or its tablets for use as a medicament, or use of nitisinone, or use of oral formulations of nitisinone for manufacture of nitisinone in treatment of anti-cancer, or in treatment of whatever small cell lung cancer. So SMC, small lung cancer cells, or method of preparing nitisinone. So that is the process claims. So these are like few examples. There are so they've given some 5 or 6 situations. I will just show you the situations, and then we can stop there. Compound X is the state of the art. So compound X is already known, and it is suitable for treatment of Y. So that's what you have found out. So now how will you claim compound X, or composition for use as medicament, or use of compound X for manufacture? So the second part is known as Swiss claim. So then if the prior art discloses a generic formula and gives no information on starting substance, you can have possible claims like specific compound A falling under general formula. So certain intermediates, this is the way how can you, that as you can claim it. Then if the prior art discloses a general formula, and it gives us precise information on starting substances to produce compounds falling under generic formula and prior art A, So in that case, specific compound A falling under general formula is not novel because that is something which is already existing in prior art. Then prior art discloses a general formula and gives a precise information on starting substance. Um, and to this extent, the prior art discloses list of 1 and 2 of starting compounds, and that has to be reacted with a member compound. And prior art will not explicitly mention the specific compound that is of our choice, which is inevitable result from the starting compound. So here in this case, the simple possible claim is specific compound A falling under general formula. So see, they write from simple situation to a complex situation. EPC has guided us on how to draft the claims. So simply then, if there is a racemate which but does not disclose enantiomer, you can claim enantiomers. Then you can claim polymorph if the prior art discloses the compound, like claim directed at polymorph A or cefdin or whatever. So that way, so likewise, as you can see, uh, there are different examples that are given. So thus different claims must be read. So this is the way you can draft the claims. It is always advisable to draft fewer claims. Too many claims, it leads to it leads to confusion of the examiner, and sometimes it so happens that if there are too many claims, the examiner just gives you a back gives it to you back to describe the unity of invention. So in that, the dialogue for prosecution just lengthens. So one has to see that the presence of dependent claim should add a particular limitation which is necessary. So just write the necessary claims, and all the claims should have different meanings. You can't repeat the claims with the same meaning as in the earlier claim. So some of the practical tips is draft a full range of claims from broad to narrowest. Draft, if there is a commercial embodiment, you see that whatever is your commercial product should be covered by your claims. If there is a composition claim or use claim, should be included in that patent wherever is appropriate. Attempt to use fewer independent claims. See that claims vary in diversity and type. As I told you, try to draft claims with different meanings. Avoid overly broad claims or picture claims, in the sense sometimes people just say the formulation comprising of, and then just copy the table. So that's a picture claim. Don't do that. Instead, you can have the range of the excipients that is claimed. Avoid repetition of dependent claims, or consider the continuation filing of continuations. So these are certain practical tips to draft the claims. So I think let's stop here, and then we'll continue with infringement and some case examples tomorrow.
Thank you, madam.
I hope it was interesting. If there are
Yes.
any questions, everyone is welcome to ask.
Really, madam, it was very interesting session today. Number of things I got from your lectures, today's lecture: patent application, then PCT, then patent types, etc. Number of things I will explain. I will say tomorrow in the in the vote of thanks. Now at present I'm having 4 questions, madam, from the chat box. Few students they ask few questions.
Sure.
Number 1 is uh, this is a question during madam, this is there on the screen.
Yeah.
During pandemic like situation, if a company comes up with a novel drug for the cure, so filing for its patent procedure will be same or there will be some modification?
So this question has 2 or 3 parts. Varshita has asked this, right? So
Yes,
if in
yes.
a pandemic situation, say for example, if a company comes up with a new vaccine, let's take an example of vaccine as an example here. uh, filing for its patent procedure, the procedure will not be any different, but you can always ask for expedited procedure, expedited examination procedure from filing. And under Indian Patent Act, we can get a patent granted in maximum 6 to 8 months under that expedited procedure. But the filing procedure or forms etc, nothing changes, that remains. So that is in short I've answered. But if it is say vaccine, my second edition of answer to Varshita is, if it's a vaccine, that we are not going to only file vaccine, you are also going to file vaccine, its method of preparation, vaccine as a product, vaccine as a process to manufacture, vaccines use. So we are going to file continuation applications, or we'll also file patent of additions, and we'll also file different patents for one particular product. So now it may so happen that you may get the vaccine or the base patent within 6 to 8 months, and then later on additions you can get it in the length of time, or then you can keep lengthening the cycle. So I hope that answers Varshita's question.
Okay, thank you, madam. This is the next question by Manjari Singh. She asks average expenditure for a patent.
That's a good question, Manjari. If you want to file it in India as an individual patentee, in the sense you're not associated with any company, or you are not assigning your invention to any company. If it's an independent this thing, then it is till the maintenance, the fee comes to approx around 3 to 4 lakh of rupees. And here I'm just not counting the complexity in your patent application. If you go to file PCT application, the PCT filing fees is itself is 1 lakh rupees. So that costs more than 5 to 8 lakh rupees, provided you choose 5 countries. Now in those 5 countries, if you choose Europe, Europe has, that 36 member countries, and if you get a European patent granted, you need to validate the European patent in each of the European country, and each of the European country has different validation fees. So that is not counted in this 7 to 8 lakh rupees. So that depends on whether you want to validate in all EU countries, or the EU countries where you want to market, or only the first 5 European countries where you want to market. So the expenditure would depend on that.
Thank you, madam.
Okay.
Then the next question is from Shehraz Ansari. He asked, if we forget to renew the patent when it is expired, is that we have a file for a new patent?
No, the answer plainly is no, but there is, if I was explaining in my lecture, that if you forget to renew the patent, say for example, you forgot to renew for 2 months or 6 months period, it's for those 2 months or 6 months, if it is a genuine reason, and you can explain it to patent office when you have to apply for with justification for renewal from that particular date, and patent office will renew. But during those 2 to 6 months, if somebody has come with an infringing product, you cannot assert your right for those 2 to 6 months. So that doesn't amount to file a new patent, but you have lost your protection for that particular period. So you have to be very, very careful, therefore, if it is an invention which is important to you, you just can't forget the maintenance date. And you have to be aware that even if you forget maintenance and you want to revive it, unless there is a genuine reason, patent office does not revive the patent, and if they revive it, you have lost the period for that particular time.
This is the last question from, thank you, madam. This is the last question from Students Corner. Manjari Singh, again, she asked, more the claims, then stronger a patent?
Unfortunately, no. I just said that in my practical drafting tips, that draft fewer claims, but at the same time one has to in the application that I showed you was a CSIR. You could see that it was a composition with 5 plant extracts, and yet they had only 10 or 12 claims. So the strong strength of the patent does not depend on the number of claims. The strength of the patent depends on the features that you claim. So if you are able to claim all the essential features correctly, that leads to a stronger patent. So the if you keep on adding claims, what you will do is you will confuse the examiner on your essential, preferred, and optional features. So if you keep the claims clear, concise, and fewer, it is easier for examiner to understand or have the clarity of the invention. And once he has clarity of the invention, he'll immediately grant your patent. That is in your benefit.
Uh, and this is the last question again asked by Varshita. Renewal of patent comes under patent period.
Yes,
She asked.
every country has their own renewal rules, and if you go under Indian Patent Act, behind the Patent Act, it comes with patent rules, and within rules you have they have given you the period, like every year you can pay, every 2 years or every 3 years, as per the rules suggest. So you have the certain number of money, which is, certain money is given, which you need to pay at the end of 2 years, at the end of 4 years, at the end of 5 years, at the end of 8 years. So likewise, they have already given you the renewal periods.
Okay, thank you, madam. A teacher has to be again and again be a student. As a part of this statement, I am from my side asking, madam,
Yes,
very few
sure.
small question. I am thinking so, but suppose anybody asks me, either he or she, then to him I should explain, to him or her. Just let me know the difference between a patent drug and patent cum proprietary drug as
Sorry.
per the Patent Act. Just a patent drug and patent cum proprietary drug. Is there any difference or one and same, madam?
It can be one and same, but when you say that it's a proprietary drug, see, when you say patent drug, so it can also be, it can mean Marcouche as well as general. So Marcouche as well as specific. So when
Acha.
we say that it is patent drug, it will cover the entity as a whole. Then whatever you do, if you do OH addition or if you do CH2 addition, that will lead to you as, aripiprazole ester or aripiprazole phosphate, whatever, like sitagliptin phosphate. So that is what is your commercial entity. So your proprietary drug is your commercial entity, sitagliptin phosphate. So sitagliptin base patent would cover sitagliptin also and sitagliptin phosphate also. And plus you can also have a patent which is claiming specifically sitagliptin phosphate and it's used as a second patent.
Acha.
So that's
Okay,
a
madam.
that's a difference if you want to differentiate. But otherwise, the act wise, it means the same thing.
Okay, madam. Okay, madam. Thank you,
I
madam.
hope I answered your question.
Yes, I got it, madam. Then again, there is a small little question. It may be a silly question, maybe, but I should ask. As madam, there is under the as per government, there is organization that is called as Ayush, which comes under Ministry of Health.
Correct.
Uh,
Ayush Mantralaya.
is there any money concession for patent of medicine from alternative systems of medicine? For example, we are
Uh,
going for patenting the drug from alternative systems of medicine, like Ayurveda,
Unfortunately, no.
Unani, or Siddha. No.
No,
Acha, acha.
no, no.
Okay, madam. Okay, okay. Thank you, madam.
At at present, only individual and corporate are the two distinguishes that. So PCT wise, you have SME, that is small manufacturing concession. You get it. That is PCT. But as per Indian Patent Act, there is no distinction.
Okay, madam. Thank you. Madam, this is the last question from again the student. Huh? कौन सा है?
I can
अच्छा,
see
there
the
are two
question on the
questions.
screen.
Yeah. Yes, madam.
Patent is a
Can the
territorial right. Yeah, so it cannot be, same patent cannot be used in different countries. It has to be filed and prosecuted and granted in the different countries. So one patent you can have, as I told you, you can file through PCT and you can get it granted in different countries differently. So the claims would be different. It can be one invention. So, but the rights or the claims would be different for the same invention in different countries, because it is a territorial right.
Okay, madam. And surely this will be the last question from Minal Dubey, our student. In the duration of 8 to 9 months of filing patent, if anyone comes up with the same kind of product, what can be done?
If you have filed a patent, complete specification and first go, then the 8 to 9 months of filing patent shouldn't bother you, because when it comes to examination, that will be seen as a non-published prior art. If your application would definitely be still considered as non-published prior art, because it is not published. But if it is a provisional application, then it's an unreserved ticket. Whomsoever comes up with a claim, filing of claim, so that is complete specification, would be treated as the priority date. So if someone is coming up with a, you have filed a provisional, if someone comes up with a complete specification, even after 8-9 months, the person who has come up with complete specification would get the priority date, because you have not filed the claims as yet. That is why I
Okay,
told
madam.
you that provisional is an unreserved ticket, and to the journey, and complete is a reserved ticket to the journey. So if you remember that, that sorts the problem.
Okay, thank you, madam. Madam, with us, our principal madam is there. Madam, do you want to have words to speak up there here? अजय, बंद है मैडम.
Somebody, you're not
माइक्रोफोन.
audible.
My, I already have patented 2 products, but I gave it to the professionals. But with all these sessions, now in the future I will be doing myself, so that I can
That's
save
it.
money. Lakhs of rupees being paid. Okay.
Yes.
Exactly, madam. Exactly.
Very good
Uh,
sessions. We are again meeting tomorrow, and in these 2 days I was really very busy, but I will keep myself free tomorrow, and then I can ask questions also, because I was busy
Sure.
in administrative work. Definitely I will be attending it tomorrow. Okay. Yes, sir.
okay, thank you, madam. Dear students, kindly fill up the attendance sheet which is sent to you already in the chat box. Please kindly find the chat, see the chat box, and send the attendance at your earliest. So okay, thank you, madam, principal madam, and Alka Mehta madam. Thank you for your kind concern and a huge information provided to us, especially to me, and then all other students who are there on this online platform. Thank you very much, madam.
Thank you.
Thank you, Alga. Thank you
Thank
so
you.
much. Bye
Bye.
bye. See
Bye.
you.
Thank you.
Bye.
Tomorrow we'll meet at 3 p.m. sharp. Thank you, students.